Welcome to Sexual Harassment Training. This training is brought to you by HR Lab Los Angeles. Today we are going to review 1. The elements of sexual harassment and the remedies available to victims of sexual harassment under both California and federal laws. 2. Discuss other forms of unlawful harassment. 3. Consider strategies for preventing and responding to unlawful harassment. And 4. Address concerns regarding abusive conduct in the workplace. Introduction. Sexual harassment training is not required under federal law. However, many states have enacted legislation specifically requiring sexual harassment training. This training is, however, required in the state of California. The Supreme Court's landmark decisions in the 1998 Farrar and Eller sexual harassment cases, subsequent court decisions and Equal Employment Opportunity Commission (EEOC) guidelines make it clear that sexual harassment training is essential. As supervisors on the front line, it is essential that you know how to recognize sexual harassment and how to respond and prevent it. Disclaimer. The information in these materials, as well as any additional information provided by the presentation, should not be considered legal or accounting advice. Attendees should consult with legal counsel before taking any actions that could affect their legal rights, and should not consider these materials or discussions about these materials to be legal or other advice regarding any specific matter. This training has been created and edited by HR Lab LLC. The training may not be duplicated, reproduced, distributed, or ingested into a third-party system such as an employer's e-learning platform. These materials conclude the supervisory training. The duration of the training is 60 minutes. According to NPR, only 1% of sexual harassed victims confronted their harassers. 99% of employees successfully recognize a sexual harassment situation. Even though the Bureau of Labor Statistics finds that 70% of employers provide sexual harassment training and 98% of companies have sexual harassment policies, there is still a significant number of sexual harassment claims filed every year. What is sexual harassment? Sexual harassment is unwelcome conduct of a sexual nature that is persistent or offensive and interferes with an employee's job performance or creates an intimidating, hostile, or offensive work environment. Where can workplace sexual harassment occur? Whenever and wherever employees are fulfilling their work responsibilities, including employer-sponsored events, conferences, office parties, and off-site or during non-work hours. What is retaliation? Any action to alter an employee's terms and conditions of employment because that individual engaged in a protective activity. Examples: sudden change in work schedule or work location, or demotion. What is not retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in protective activity. Protected activities. An employee engaged in protected activity is protected by law from being retaliated against. This includes making a complaint about harassment or suspected harassment, providing information during an investigation, or testifying in connection with the complaint. Now you will be watching an example video on retaliation. Enjoy!
In an employment law context, retaliation occurs when an employer takes an adverse action against an employee, such as firing the employee, because the employee has engaged in a protected activity. Employers who lawfully retaliate against employees may be penalized or required to pay damages to the affected employees. An employee can engage in a protected activity by either participation or opposition. For example, an employee may file a claim against the employer for violating the law. An employee may also testify in a proceeding or assist in an investigation related to an employer's misconduct. An employee may also engage in a protected activity via opposition by making complaints to management about the company's violation of the law, protesting against violations of the law, refusing to engage in an activity that would violate the law, or expressing support of coworkers who have made complaints or filed charges or lawsuits against the company. If an employee engages in a protected activity and the employer takes an adverse action against that employee, then the employee may have a claim for retaliation. Adverse actions are actions that would dissuade a reasonable worker from engaging in a protected activity. These include firing, failing to promote, reducing wages, changing shifts or schedules, issuing discipline or poor performance reviews, or decreasing opportunities for advancement. It is not enough, however, for the employee to prove that an adverse action occurred after the employee engaged in a protected activity. The employee must also prove that a causal connection existed between the protected activity and the adverse action. This typically means that the person who made the decision to take the adverse action was aware of the employee's protected activity and that it factored into the adverse decision. If, for example, an employee complained to one manager about a violation of the law, but a different manager decided to fire that employee without knowing of the complaint, there will not be a causal connection, as one cannot retaliate for actions of which one is unaware. Additionally, to prove a causal connection, the adverse action must be somewhat close in time to the protected activity. This means that not too much time can pass between the protected activity and the adverse action. For example, if an employee refused to perform a certain task because he believed it was a violation of the law and then was fired a year later, the court may find that too much time passed in order to establish the adverse action, in this case the firing, was causally connected to the employee's protected activity. If an employee can prove that he or she engaged in a protected activity, suffered an adverse employment action, and there was a causal connection between the protected activity and the adverse action, then the employee has established a prima facie case of retaliation. The employer can defend itself, though, by setting forth a legitimate, non-retaliatory reason for the adverse action. For example, the employer may assert that the employee was fired because he was repeatedly late or absent from work. If the employer is able to set forth a legitimate, non-retaliatory reason for the adverse action, then the employee will need to show that the reason provided by the employer was not the real reason for the action, but merely a pretext, and that the real reason was, in fact, retaliation. An employee can show pretext in different ways, including by showing that other employees were not fired for engaging in the same conduct and were not adversely affected. Pretext can also be demonstrated by showing that the employer shifted its explanation for the adverse action during the process. An employee who successfully shows pretext may be entitled to recover damages due to retaliation. The type of damages an employee can recover depends upon the law the employer has violated. Damages may include lost wages, compensatory damages, for example, for lost salary or emotional distress, and punitive damages. The employee may also be entitled to repayment for any attorney's fees he or she incurred for pursuing the retaliation claim. There are many laws that prohibit employers from retaliating against their employees. Individual states have laws that protect whistleblowers in some form. A whistleblower is a person who reports an organization's misconduct. Additionally, there are a multitude of federal laws with anti-retaliation provisions, including the Age Discrimination in Employment Act, the American Recovery and Reinvestment Act of 2009, the Americans with Disabilities Act, Commercial Motor Vehicle Safety Act, the Consumer Financial Protection Act, the Consumer Product Safety Act, the Dodd-Frank Wall Street Reform and Consumer Protection Act, the Employee Retirement Income Security Act, the Fair Labor Standards Act, the Family and Medical Leave Act, the National Labor Relations Act, the Occupational Safety and Health Act of 1970, the Patient Protection and Affordable Care Act, Sarbanes-Oxley Act of 2002, Title VII of the Civil Rights Act of 1964, the Uniformed Services Employment and Reemployment Rights Act, and the Whistleblower Protection Act. As the number of laws with anti-retaliation provisions has increased, so has the number of retaliation lawsuits. The number of retaliation claims filed with the Equal Employment Opportunity Commission has steadily climbed over the past decade. Retaliation claims accounted for nearly half of the charges filed with the EEOC in 2016. With retaliation growing as an area of concern for employers, companies may seek to prevent retaliation by implementing anti-retaliation policies, training employees and managers on these policies, setting up formal avenues for employees to make complaints, and establishing and following processes for the investigation of employee complaints.
Sexual harassment protocols. Policies and procedures. Sexual harassment can be prevented if the proper policy, procedures, and protocols are in place. These policies should include bystander interventions as a required response to predatory sexual behavior. By doing so, it relieves the target of their sole responsibility for reporting and stopping predatory sexual behavior. As well, it puts the responsibility of establishing a healthier organizational culture on all team members. Investigation and corrective action. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action. An investigation of any complaint will be commenced immediately and completed as soon as possible. The investigation will be kept confidential to the extent possible, and any employee may be required to cooperate as needed in an investigation. Investigation process. An internal investigation unit will conduct an immediate review of the allegations and take the needed action. Relevant documents, emails, or phone records will be requested, preserved, and obtained. Interviews will be conducted. The individual who complained and the accused are notified of final determination and the appropriate administrative action that is being taken. Limited confidentiality. Employers can only promise limited confidentiality, that the information will be limited to those who need to know. An investigator cannot promise complete confidentiality because it may be necessary to disclose information obtained during the investigation in order to complete the investigation and take appropriate action. Bystander intervention tips and strategies. Why is bystander intervention important? Preventing sexual harassment is everybody's responsibility. Sexual harassment can be prevented if we, as bystanders, choose to intervene when we see or hear behaviors that threaten, harass, or otherwise encourage sexual violence. How to be a good bystander. It may not always be safe or effective to directly confront the harasser. Still, there is a range of ways bystanders can be involved before, during, or after a situation occurs. We have some tips for you next. Confront the harasser. Disrupt the situation, intervene. Don't act alone. Reach out for support. Focus on the needs and experience of the target, and ensure they receive the support they need. Set the expectation to speak up and step in. Being transparent and responding directly to inappropriate behaviors can and will encourage others to be more responsive. It shows that as a supervisor, you recognize that the comment or behavior is unacceptable and you don't tolerate it. You can address inappropriate comments by saying, "I can't be the only one who thinks this is not okay. I don't see how XYZ is relevant or appropriate to this discussion." Understand how you are positioned to speak up. Being a supervisor comes with the huge responsibility of leading by example. It is your duty to model respectful behavior and speak up about harassment, especially when you are not the target or representative of the target group. Be proactive. Plan ahead and practice with friends and family what and how you would say it if you are ever facing a situation where you need to confront a harasser. Ask yourself, how would you like to be treated, and use emotional intelligence to see others' perspectives. Use kindness and compassion. An active bystander is someone who has the moral courage to find a way to safely intervene to stop a potentially dangerous situation. Your responsibilities as a supervisor. Supervisors and managers are held to a high standard of behavior. They are required to report any harassment reported to them or which they observe, responsible for any harassment or discrimination they should have known about, and expected to model appropriate behavior. Mandatory reporting. Supervisors must report any harassment that they observe or know of, even if no one is objecting to it. Harassment must be promptly reported to the employer. Supervisors and managers will be subject to discipline for failing to report suspected sexual harassment. Supervisors and managers will also be subject to discipline for engaging in retaliation. Sexual harassment versus sexual attraction. Sexual harassment is a form of discrimination and has nothing to do with one person's physical attraction. It is a misuse of power. What should I do if I am harassed? You will be provided with a complaint form to report harassment and file complaints. You may also make reports verbally. What should I do if I witness sexual harassment? Anyone who witnesses or becomes aware of potential instances of sexual harassment should report it to a supervisor, manager, or designee. It is unlawful for an employer to retaliate against an employee for reporting suspected sexual harassment or assisting in any investigation. You will now be watching a video of the bystander effect.
That was amazing. I'm so glad I found you. I can't wait for the next phase of this.
First, the upstander could intervene directly at the time, calling out the conduct or acting to get the person out of harm's way.
Hi, Joseph. Joan, would you like to help me with something?
She could also email or speak with the bad actor later to let them know she saw what happened and that the behavior was uncomfortable or unwelcomed.
Hi, Joseph. I saw you in your office with Jill the other day. Maybe you couldn't tell, but she was clearly not comfortable. I thought it might help for you to know.
Or she could reach out to the victim to let them know she supports her and will come forward with her.
I know. You looked so uncomfortable. I just wanted to get you out of that situation. Do you want to get together and have some coffee and talk about it?
Finally, the upstander could report the misconduct by talking to a supervisor, someone in HR, or by using reporting mechanisms like hotlines or online reporting if they're available.
Yes, thank you for making time for me today.
Overall, when bystanders remain silent, it normalizes sexual harassment in toxic or hostile work environments. Remember the 3 Ds in your role as an active bystander. Direct. Point out threatening or inappropriate behavior in a safe, respectful manner. Distract. Make up an excuse to help the friend get away from someone who might pose danger. Delegate. Ask some of your coworkers for help being direct or distracting. Strategies to prevent sexual harassment. Take swift and decisive actions as issues arise. Lighten up on the legalese. Make it crystal clear that sexual harassment prevention is a company priority. Make sure that employees and management understand what sexual harassment is. Keep sexual harassment prevention training positive. Additional protections and remedies. United States Equal Employment Opportunity Commission, EEOC. An individual can file a complaint with the EEOC anytime within 300 days from the alleged sexual harassment. You do not need to have an attorney to file. A complaint must be filed with the EEOC before you can file in the federal court. For more information, visit www.eeoc.gov. Local protections. Many localities enforce laws protecting individuals from sexual harassment and discrimination. Contact your country, city, or town to find out if laws exist. Harassment may constitute a crime if it involves things like physical touching, coerced physical confinement, or coerced sex acts. Embracing civility. According to a global annual poll on workplace incivility by McKinsey & Co., 62% of employers were treated rudely at work at least once a month in 2016. Since 1998, when the poll began, rude behavior has increased at an alarming rate. Every year, chances go up that your leaders and employers are being dismissive and demeaning to one another. Now you will be watching an example video on civility in the workplace.
Unfortunately, in today's society, toxic work environments are rampant. Many assume this toxicity is just the way it is and accept there is nothing we can do about it. Disrespect, gossip, poor communication, and cultural insensitivity are just a few examples of this dysfunctional behavior. There. Oh, I didn't see you there. Hello, I'm Tammy West, and I am so frustrated with the lack of civility in today's business world. Have you ever witnessed such behaviors in your workplace? If not, let me show you.
Hey, do you have a minute? Okay, yep, that sounds good. Thank you. Hey, so I have a great idea. What about a new e-commerce system where we can put all of our products online? And I ran some numbers. I think it'll improve our sales by 20%. So what do you think?
I think that's a really good idea. I'd really love for you to put together a portfolio. Let me look at the numbers tonight, and I'll bring it up at the meeting tomorrow.
Thank you.
Yeah, thank you for taking the initiative. I really appreciate that. Okay, sales team, thank you all for coming in this morning. I want you to take a look at this proposal I put together. It is for a new e-commerce platform. Now, Kylie, honey, can you go get me some coffee? Sure. So I put these numbers together last night, and I think that this new e-commerce system will increase our sales by 20%. Now take a look at the numbers. Let me know what you think.
I think this is a very good idea. Who came up with this?
I did.
Wonderful.
Yeah, I know. I just came in my head last night. Brilliant, huh?
Mhm.
Yes,
Yeah.
absolutely.
Oh, hey Chloe, how are you?
Hey, how are you?
I'm good, good. So did you hear? It's all over the office what Molly did this weekend.
No, I did not. Tell me.
Hold on. I don't want to.
No.
Oh, and can you believe it? Actually.
Yeah, I mean, it's Molly. Thank you all for coming to this meeting this morning. So as you know, we're going to talk about our e-commerce sales. It's supposed to go up by 20% if we do this, and you can see by this graph over the next 5 years, our trajectory sales will.
20%. This really, I'm just confused by what you're trying to communicate with this. I feel like you're way off base with just the beginning of this presentation.
Oh, Russell, just the person I was looking for. Hey, so, don't hate me, but I know you asked off for Passover or whatever it is your people do, but I'm going to need you to come in on Saturday. It's really important.
First of all, I'm busy on Saturday. And second of all, I asked off for Ramadan.
Whatever.
Toxic, right? Now let's take a look at these scenarios with a dose of civility.
Guys, thank you all for coming in this morning. I really appreciate it. So, I have some really exciting news. Kylie put together a proposal for an e-commerce platform, and her numbers show that it will increase sales by 20%. Everyone give Kylie a round of applause.
Oh, pretty good.
Thank you. Oh, hey Chloe, how are you?
Good, how are you?
I'm good. So I've got some really juicy gossip. Did you hear what Molly did this weekend?
No, and I don't think we should be having this conversation right now. It's not really appropriate for work. If Molly wants to tell me, she'll tell me.
Whatever.
Thank you guys for coming to the meeting this morning. I really appreciate your time. So as you know, we're going to talk about our e-commerce sales. If we do put these products online, our sales are supposed to increase by 20%, and you can see that over 5 years, these are our trajectory sales.
Excuse me.
Yes.
The email you sent this morning had different data. Could you elaborate?
Yeah, of course. Yeah, sure. So from the slide that you got.
Oh, Russell, come in. Just the person I was looking for. So, I know that you asked off for Ramadan, and I made a scheduling error, and I had this project due, but I really want to respect your holiday. And so, is there any way we can figure out a way to get this done before then?
Yeah, that'll be great. I think we can do it.
Okay, perfect. I'll call you later and we'll figure it out.
Sounds good.
Rude behavior is bad for businesses. According to the American Psychological Association, workplace stress over the past decade has cost the U.S. economy billions each year. When employee incivility goes unaddressed, organizations also experience higher turnover, more absenteeism, and lower productivity. What can a manager and/or supervisor do to ensure that people on their team treat each other with respect? Create a respectful workplace. Practice active listening with your staff. Actively listen to your staff. Show them that you really care about them as an individual and that you respect their feelings. Appreciate the talent they bring to the table. Uphold a zero tolerance policy. Make sure everyone in your company understands that there is a zero tolerance policy on discrimination, bullying, and sexual harassment at your company, and that disciplinary actions will result if policy is violated. Make respect and courtesy a part of the company culture. The best way to make respect and courtesy a part of the company culture is to model it yourself and make sure all your management staff models it as well. Greet all employees by name, take an interest in their personal lives, and show them courtesy by showing up to meetings on time and making sure everyone gets to contribute to important discussions and planning. Encourage your employees to succeed. Provide your employees with plenty of opportunities to learn new skills so they can be promoted within the company. It is the best way to empower your employees. Everyone works a little differently. If possible, give your employees the freedom to work at their own pace, as long as they get the job done well and in a feasible amount of time. Create workshops to teach respect. Respect may seem like an easy thing to practice, but a lot of times we don't realize that our words and actions are hurtful to someone else. Constantly interrupting someone or depreciating their ideas is actually bullying and must stop. Be aware of your body language and tone of voice. They can relay a message we often don't realize we are sending. Check in with your staff regularly. Try sending regular climate surveys to give your employees a chance to anonymously express any frustrations or serious issues they are having at work. Pay your employees what they deserve. Lowballing on salaries instead of offering at least a standard norm will make your employees feel underappreciated and taken advantage of. It may seem like you are saving at first, but will be very costly in the long run. Summary. Sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. It affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. Employees who are found to have subjected another employee to unwelcome conduct of a sexual nature will be subject to discipline or other appropriate management action. The taking discipline measures will be appropriate and relative to the circumstances, ranging from a letter to suspension without pay of varying lengths to separation for cause. It is important to prevent sexual harassment in our workplace because it harms us all. It conflicts with the company's value that all employees are treated with respect and dignity. Sexual harassment and retaliating against an employee who complains of sexual harassment are illegal under federal and state laws. The two forms of sexual harassment are quid pro quo and hostile work environment. Retaliation is taking adverse action against an employee who has complained of sexual harassment. It is just as illegal as sexual harassment and it is strictly prohibited. Your responsibilities as supervisors include 1. Complying with company policy and procedures. 2. Immediately reporting any complaints you receive or incidents you witness to HR or management. 3. Handling complaints from your employees in accordance with company policy and procedures. 4. Never retaliating against an employee who complains of sexual harassment. 5. Assisting with investigation and disciplinary action. 6. Ensuring that victims are not adversely affected. And 7. Making sure that sexual harassment stops and does not reoccur. Supervisor's obligation to report harassment. The Office of Civil Rights, S/OCR, is the main contact point for questions or concerns about sexual harassment. Supervisors and other responsible department officials who observe, are informed of, or reasonably suspect incidents of possible sexual harassment must immediately report such incidents to S/OCR. S/OCR will provide guidance as needed on investigating and handling the potential harassment. Supervisors/managers who observe or are informed of allegations of harassing conduct must take immediate steps to ensure employee safety and prevent the harassing conduct from continuing. Report the conduct/allegations to the appropriate officials even if the employee raising the allegation requests confidentiality. Ensure that a prompt, objective, and thorough investigation is conducted. Take steps to ensure that the harassing conduct is appropriately addressed to deter further misconduct, including taking disciplinary action if appropriate. Motto: respect yourself. Employees want to know that you also engage in the same behavior you expect from them. We appreciate your participation and hope that we have provided useful information regarding 1. The advanced elements of sexual harassment and the remedies available to victims of sexual harassment. 2. Strategies for preventing and responding to unlawful discrimination, harassment, and retaliation. And 3. Your responsibilities as supervisor. It's time for a quiz. Please complete the quiz provided by your employer. Thank you for your participation. Bye.